Hey, right, everyone. Just bear with me a sec. Here we go. I've been slightly more efficient than normal. Yeah, cool. So, hold on, got some more questions coming last minute. We'll have to miss them. So, yeah, welcome to tonight's live stream. You're right, Michael. As normal, please don't ask questions that involve sharing your personal data on the internet. You don't need to. Just phrase your questions as what if questions. You'll get the same answer. And this ain't legal advice. We're going to do our best to be useful, but yeah, we are limited in terms of what we can say. Plus, we get stuff wrong from time to time. So, that being said, let's get on with it. So, we've had 7 questions come in through the week. Uh, four of which, at least 4 of which, are anonymized. So, we'll do them first, and then we'll come to the live stream, start crunching through those ones. Just bear me a sec whilst I get the first one lined up. And the first one, in fact, I'm not entirely sure I quite understand it, but we're going to have a go at it anyway. Wait a minute, is my camera playing? Oh, sorry, guys. My camera, I think it's the USB cable, I think. Bear with me a sec. Let's see if I can make that work. You can still hear me, yeah? Yeah, cool. Just right, I can see if my camera wakes up again. It's made a beep noise. Yeah, there we go. Should do. Yeah, there we go. Cool. Yeah, try not to go anywhere near that USB. So what was I saying? Yeah, so let's get up and running. So question 1 from the week. And just to say, as I always do, if you're wanting to ask questions on the live stream, the best way to do it is still to ask the question in advance by just going onto any video on the channel and just asking it there, basically, because you'll then be able, there's no character limit. You can kind of put the full question in, and it also gives us a bit of time beforehand just to kind of actually look at the question, so we're not kind of caught on the caught off guard. So yeah, number 1, what can one do if the council still does not treat a person as homeless, even though the contract ended 10 days ago, the notice to quit was handed over? So, because homelessness law is a legal thing, you have to be quite pedantic, and I guess we just need to kind of work out exactly what the question is here. So, it may well be a question about whether someone has been, someone's made a homeless application, they might be given a valid Section 21 notice, and the notice is expired. That might be what the question's getting at here, in which case there's loads of stuff on the channel we've done already, so we're not going to go over that tonight. But effectively, you're likely to be legally homeless the day after the valid notice expires, unless the council can or think they're going to be able to convince the landlord to allow you to stay. But in terms of notice to quit is, at what point does is notice to quit even the right jargon in the Section 21 process, or is it? Yeah, because I say it's notice to quit is generally what you talk about in temporary accommodation or supported accommodation. I'm not actually sure if it applies within the Section 21 process or Section 8 process for that matter. But Will or Karis, your best place to answer these ones, because yeah, we don't know. Me and Shannon don't deal with this stuff very often.
Shall I barge in before Paris gets a
Yeah, go for it.
chance? Sorry. The strictly speaking, the notice to quit is and stop me if this goes, I'm going into too much detail, but notice to quit doesn't really play a part in the Section 21 process or the Section 8 process. What a notice to quit is the sort of ancestor or the thing that was there in the first place before statutory notices came in. So it's a notice, as it sounds, to leave, and it applies still in if you have a lodger or if you have somebody. If you wanted to get a squatter out, you would initially serve a notice to quit. Well, basically anyone who doesn't have a statutory tenancy, and that would be obviously an assured tenant has a statutory tenancy, somebody who has a private sector tenancy, so they would have to have a notice of seeking possession. Um, and so somebody in, so I had one the other way, somebody who was in home office accommodation, provided pending the outcome of an asylum application. When their asylum application succeeded, they got a notice to quit, and that was because they had a non-secure tenancy. So basically, it's what you get if you haven't got an assured tenancy, or an old rent act. In fact, I think a rent act tenancy under the old rent act, you'd serve a notice to quit then. I may be wrong, but it's basically anything other than a assured tenancy which has a notice of seeking possession.
Cool. Thanks, Will. That was all Greek to me, but I think it's probably good. I mean, it's good to understand that it is all rather complicated, and I think also,
Yeah.
I think in the coming months, I'm sure we'll do some stuff around the changes to the legislation around Section 21s and the Renters' Rights Bill and stuff like that when it comes in. Hey, you right, Katie? You right, Tiff? So yeah, I'm trying to think what else this could be. So yeah, I think we're probably talking about a Section 21 notice. And in one sense, in this situation, I'm trying to think practically. So let's say the council was just refusing to accept you're homeless, and therefore they're presumably keeping you under the prevention duty at this point. I'm not quite sure. I'm not quite sure how or what decision you're actually asking for a review of. But I think you can basically challenge it through the review process. But often by the time you actually get through the process, things will have changed anyway. It might actually be better to go down the complaint route if this is the situation, because you're probably more likely to get some fresh eyes on it in the kind of a bit sooner. So yeah, as I say, it's not quite sure what the question's getting at, but I guess it just kind of highlights, if nothing else, that there's a lot of jargon that people have to navigate when they're asking these sort of questions. And understandably, yeah, kind of it's quite difficult sometimes to convey the actual the situation as it's happening. Um, if that person wants to come back and actually clarify the question, feel free. Obviously, we'll come back to it. Um, question two. This is yeah a bit clearer, well a lot clearer. So what do you do when the council says you're on a joined tenancy, even if you're divorced and don't live there for over a year? How do you remove oneself from the tenancy and apply for council house as a homeless single parent? And then, so this is basically, there's actually kind of two questions in one. I probably shouldn't have separated them actually, because the second bit does kind of help us with the first bit, or kind of give us more to the first bit. So we'll call it question three, but it's the same person asking the question. And it's talking about 50-50 share, kind of childcare of the child, and how that conveys or confers priority need, whether it can confer priority need on both parents. So if we deal with this with question two first, and this has actually been popping up a few times, this kind of question recently, and then my answer's kind of consistently been the law on this is actually pretty bad. Because there was this old case called Moncada in 97 or 98 or something, and effectively they were separated. I don't know if they're married or not, but they I think they probably were married, separated a couple, and new partner had moved in with the wife, and essentially the husband came back on the scene and was expected by the judge to continue living in the home, even with the ex-wife and her new partner living there, which is pretty ridiculous. But that's where things stand at the moment, as far as I know. So in one sense, that's the issue here, is that there would potentially be situations where you're not homeless legally, and the council would be correct, if they've kind of looked at the right facts or whatever. Now, what I don't know is if you haven't lived there for a long period of time, whether that would change. Now, in the Makada case, this guy had been in prison, the husband had been in prison for a few years, I think. So, in one sense, that would suggest that the actual passage of time doesn't really change anything. Um, and I think we've actually kind of, when we've dealt with this kind of question before, we've kind of raised the issue that often, I mean, yeah, it's difficult to make a generalized kind of observation here, but these kind of circumstances probably are at risk of kind of crossing the line into being abusive in some way. When you've got a kind of a volatile relationship, or a very stressful situation, it's more likely to become volatile. I'm not saying that's definitely the case here. If there was domestic abuse legally, it would change. It would be more straightforward to make an argument that you're homeless. But as I say, we're not. It doesn't seem that we're dealing with that on the question here. Um, and so, because the council could, they can say that it's reasonable to continue to occupy that accommodation. If you were then to, and remove yourself from the tenancy, however that's going to work, then I think you do run the risk of becoming, or being seen as being intentionally homeless. So it's one of those kind of cases where I think there may well be it's the sort of kind of issue which I think might crop up 30 years later from the Moncada case, and actually a judge would see it differently, because I think society's changed, and I think kind of there would be kind of a greater awareness of the risk of it turning volatile. But yeah, that's I think that's my answer. And so in one sense, to kind of put it together with question three, there's this problem that, first of all, let's kind of, I don't know which genders which here, but let's say it's the dad who's left, and it's yeah, and they're kind of still sharing the caring responsibility of the child. Let's say that it's 50-50. They're not only going to be seen as not homeless, but they also wouldn't be seen as priority need, because, again, although councils they are at liberty to find both parents in this situation to be in priority need, it's one of those situations where they can take their resources into account, and therefore almost every council, if not every council, will say, yeah, you're not in priority need. So you will have situations where often it will be the dad who basically are left to go and sleep rough, even though they are having a genuine kind of, they're genuinely caring for their child, and kind of, that being homeless is obviously going to impact on that. So yes, I think that's my kind of first stab at the answers to these two questions. But I don't know if anyone else wants to give more detail or kind of tweak what I've said there, because, as I say, it's for me, it just seems to be something which the law doesn't seem to have got right. Generally, I think the law is pretty good, but this is not, for me. This is a problem. This is going to give rise, I think, a lot of the time to risk of abuse. Shannon?
Yeah, I'm at risk of being too clever here and just making a mess of the situation. But in this situation, say the person, they've not lived there for a year and they say moved into private rented sector accommodation, surely they wouldn't be intentionally homeless, because the intentional homelessness decision is based on your last settled accommodation. And so if they remove themselves off of a joint tenancy from like two settled accommodations before,
Yeah.
arguably is that not irrelevant because it's not covered within the intentional homeless like decision? Do you know what I mean?
Yeah, no, I know what you're saying. I think the issue is that, and it's not something that comes up often, because in one sense the council might say that this person had two homes. If that was the case, if they did have a private rented accommodation for 12 months or whatever, and then they've then lost it, in one sense you wouldn't get as far as the intentional homeless consideration, because the council would simply say you're not homeless, you have somewhere to live. So I get your logic. I just think that the way I'd understand the situation would be is that you wouldn't get past the first hurdle in the homeless application process. You wouldn't even get that kind of far down the line. Obviously, if there's more to the situation, if there is another reason why it might not be reasonable to continue to occupy, or there might be reasons why this parent has other vulnerabilities or something, which means they might be in priority need, then it will be different. But as the question stands, I think it's a pretty miserable answer, really, in that, yeah, unfortunately, this is something which is happening a lot, where it is particularly dads who simply are massively restricted in terms of the input and the care they can give to their children. They might get a support accommodation place or something where they can't have the kids over, and it's very, again, very, very limited. So it's not a good situation it's not good. It's one of the many ways that the system kind of creates problems for people, very significant problems for people, that we're going to kind of probably, kind of see in the generation that's growing up in it. Yeah.
I
Shannon?
wonder if this situation where if you had an advocate or like a really banging support worker or someone to sort of fight your case and plead on there isn't the legal duty there, but obviously councils do have powers, and to really plead on that and explain, because like I am not a parent, but I imagine being away from your parents, particularly when you have 50-50 share, is quite difficult if you then can access them on your mental health, and explaining the impact of that. And I wonder whether it would be a prime situation to apply for something like a discretionary housing payment, to be like, look, obviously private rented sector is clearly my only option here. Can I apply for a DHP so it's affordable, so I can get myself sorted? And again, it sounds awful, but I think lots of local authorities are very conscious about people trying to get social housing. So if you show willing to be like, look, I'm happy to go private rented sector, and it be, potentially not as good quality, but that's not always the case, and apply for like a DHP instead, it might be like, it's not a way around it because they still don't have to, but it's,
Yeah.
yeah, potentially an avenue to explore.
Yeah, I mean, the reason why I'm slightly unsure of the answer is that I've seen Bedford Borough, which is where me and Shannon, that's where we live. I've seen them do it, and I've seen housing officers look at the situation and say, "Yeah, that's not reasonable." Although I'd say I'm not going to argue with them, because I'm like, well, I don't think you're actually right on that, but I'm obviously not going to kind of argue the other way. But so I don't. So I mean, it's certainly still worth making a homes application, and I think in one sense, what the council do need to do is give you some written advice and kind of some clarity over why they're saying. Because in one sense, they do need to issue a not homeless decision. I think there is reason to believe you might be homeless if you're going to a council and saying that you're not living there or something. I think there's enough there to kind of actually trigger the application and at least get a written decision which would explain the reasoning for saying you're not homeless. And in the course of those considerations, it might be that information comes around, or the officer is just kind of reasonable and says, okay, look, we are going to help you. Shannon says it may be there's not a duty, but the councils can still do plenty of stuff that's going to help people out. So yeah, yeah, but again, as I say, miserable situation to be in, and not a very good answer from the law, unfortunately, in this one. Karis or Will, do you want to add anything to this one at all?
No, not right now. I'm a little bit confused by the question, so I'll leave it if that's okay, because otherwise I may just be going off on a tangent with my speculation.
Okay, yeah, cool. So let me just double check question 4 is anonymized. Yeah, it is. Yeah, I think so. So yeah, question 4 is if a married couple was put in emergency temporary accommodation and only one of them is working and is getting minimum wage and taking home paying £1,500 a month, which the new rent is now £280 a week. Storage for belongings is £160 a month, and travelling cost to work is now £240 a month, as the accommodation is not local. So and so you less than 16,000. Now I think the actual 16,000 is not the. I think the threshold now is £6,000 on housing benefit. Is it something like that? I don't know if it's more for married couples. I can't remember. We'll come back to that. But yeah, basically, so the issue, if we go back a step, so again, just to be pedantic, I think we're talking about interim accommodation here rather than, that which is effectively emergency. I don't think we're talking about temporary accommodation. But if I'm wrong about that, the answer is still the same. The issue here is that any accommodation that the council provides you under a duty under the Housing Act needs to be suitable. Suitability needs to take into account affordability. And so a few things kick in here. So in effect, the council, if they're going to follow the law, they have to have a record of how they looked at the maths of this situation and said it was, they and come up with it and conclude it was going to be okay. Clearly it's not. So they would need to look into the income of the couple, and they would need to look at the maths. Has this couple got enough money to pay for the kind of the interim accommodation or temporary accommodation, and the travel and the food and the gas and electric and clothes and Wi-Fi and kind of internet and phones and so on, and also kind of pay for all that? And the answer is almost certainly no here. So the few things, other things kick in as well, because I might just go to the bit about protection of property. So in some situations, councils have a duty to protect the property of people who they owe a certain duty to. This is one of the duties that would be relevant. So if I go to chapter 20 of the Code of Guidance now, it's just worth revisiting this one, because this is exactly the sort of situation where it's relevant. Hold on a sec. Sorry. Let's just make this a bit bigger and stuff. So if we go to like 20.1, no, not 210.1. Oh, it's now beeping at me. What's going on? Oh, yeah, that's what. Yeah, so what I'm looking at, guys, for those who haven't been on the live stream before, this is the Homelessness Code of Guidance. This is the council officer's rule book. This basically tells them what to do, and it's basically legally binding. It's called guidance, but they have to have regard to it. And if they don't have regard to it, then they're liable to have to pay out compensation if they kind of cause someone injustice. But yeah, chapter 20 is all about the protection of personal property. And in effect, what it means, long story short, is if in this case, the applicant can't afford to store their own belongings, then the council needs to step in. Now, the council can do it as a loan, so they don't have to, there's not kind of free money or anything like that, but it does kind of make it more affordable. But this is relevant because it kind of comes back to this whole picture of affordability for this couple in their TA. So that is, let me bring up the question again. So yeah, but I mean, and that's the first thing. Well, that's the first two things to say. The other thing here is that, again, location of accommodation is also relevant to suitability, and so the council should again have a written record somewhere of how they believe that living however many miles away from the place of work is going to be suitable. Now, if it's costing £240 a month, in terms of travel, I mean, I don't know how, obviously this depends where it is and stuff, but I would have thought that's probably a fair distance away from where they're living and to where they're working. So yeah, the problem you've got here is that actually going back to this kind of question of whether it was interim or whether it was temporary, if it's interim accommodation, then it's more difficult to challenge the kind of the suitability of it. You basically need a solicitor because the only way to technically do it is to go through judicial review proceedings. However, you can complain, and you can involve local councillors, you can involve a local MP. And I would have thought that most councillors and most MPs would be receptive to a couple in this situation. They're working, kind of government's all about people being at work and so on. So they might be able to get the council officers to basically have another look at it and potentially realise that it's not going to be suitable. So that's my answer. Probably not the most concise answer ever, but do you guys have anything to add to that at all, or kind of clarify at all? But yeah, I think the answer is it sounds like it's not suitable through affordability and location, and also storage of belongings is an issue here. All need raising with the council as soon as possible. But realistically, it might be about waiting until a final decision's made, because once the final decision is made, let's say they owe the couple the main housing duty, then it becomes easier to challenge the suitability because you can just do it through the Section 202. You don't need a solicitor to do it. So yeah, and then I think, this is also anonymized, so we'll do this as well. So yeah, question 5. Suitability of permanent and current temporary accommodation on medical grounds is being ignored by council. Lots of medical evidence submitted and keep asking about this, but ignored, and council doctor gives a one-liner, impacting health and delaying permanent accommodation. So there is a similar question to this. I'm just wondering if I've basically just mixed up the questions. Let's come back to this because hold on a sec. Yeah, no, sorry. It's part of a longer question. I'll come back to that one later. That's not anonymized. So yeah, if you're wondering what I'm talking about being anonymized and stuff, if a question is basically identifying yourself, if you're saying I'm in this situation and I've got X, Y, and Z diagnoses, I'm trying to discourage people from doing that. I'm trying to get people to ask questions as what if questions, which is why we do the anonymized ones first. And that means we're going to go over to the live stream. So let's put this one together. Cool. I think it's just 3 parts. So Section 204 appeal was submitted to the county court 2 months ago as the council didn't make a decision of the Section 202 review. The council replied with a negative decision 2 months later. The person spoke with the solicitor, and the solicitor that the appeal is now academic. As the person has major physical health problems, should the solicitor adjust the points in the appeal so that the appeal can carry on? Can a solicitor refuse and withdraw the appeal? Can you explain, please? Does that make sense to Will or Caris here? Because again, this is very much in solicitor territory. I'm struggling to understand why a live situation would be considered academic, because presumably that at this point the person is still not got a right decision yet or good decision yet. Will, you got any ideas on this one?
Yeah, I think so. I think, and forgive me, perhaps the person who's asked the question can correct me if I'm wrong, but what seems to have happened here is that a Section 204 appeal was issued because the council had failed to carry out a Section 202 review within 8 weeks. At some point after the appeal was issued, the council then complete the review, and the solicitor says, well, that's the end of our appeal. I think the solicitor's right, but only in the sense that what you then have to do is appeal against the review decision, because what you've got is a new decision which you can then challenge by way of a new appeal. It may seem like a nuisance because you've got to go back to the beginning of the appeal, but essentially what you were appealing before was a sort of vacuum, that there wasn't a review decision. But now that there is one, you've got to challenge that. If you think about it, that makes sense because the 21 day, sorry, start again. The 56-day deadline for the council to complete the review is a starting point, and the remedy is to appeal. But if you didn't let the council issue a late review decision, then they'd be stuck, and it would be crazy if they couldn't put their point and they were stuck with just saying, well, we didn't do anything. And so the appellant is effectively kicking the ball into an open goal. So hopefully, the second decision or the actual late review decision is defective and you can successfully appeal against that. Does that make sense?
Yeah, that makes sense. Yeah, sorry. Yeah, I get what the question's about now. So yeah, so the original appeal was about the fact that the council hadn't actually provided the appeal
That's right.
the actual response. Now it
Yeah.
has. Now it's going to be about whether the council's response is right or not. And as you say, if it's not right, then take it. But yeah, as you say, it goes back to square one in terms of the paperwork, I guess. Um,
But they've given a negative decision, so essentially that's what you should be appealing. Um, any
and
problems around that, hopefully you could go for interim accommodation if you need it.
and the question that last bit, so can a solicitor refuse and withdraw the appeal?
Oh
Um,
yes, I can answer
yeah,
that.
yeah, cool.
Because there was a case, and I'm afraid I haven't been focusing. The reason I've been a bit quiet on the last questions, I was trying to find the law report, but there was actually a case where, and I couldn't quite believe it happened, but the solicitor did refuse to withdraw it and go ahead, and surprise, surprise, it was found they couldn't do that. I'm really sorry I can't name it, but the judge said no, the council can. I think what had happened was that if you think about it in practice, if you get that second review decision, you'd be very foolish just to ignore it, because it's obviously it's got a 21-day time limit on it for you to appeal it. So if you say no, I'm going to ignore the actual negative decision and I'm just going to stick with my original one, you've got the worst of both worlds. And I think in the case I'm referring to, the solicitors had sort of, to protect their position, appealed the second one as well. So the judge sort of said, well, why you can't seriously think you're going to there's anything to be gained by going for the first one because you've got a new appeal against the second one.
Yeah, okay. Yeah, that makes sense. Hopefully that's a good answer then. Um, question six. No, hold on. My old copy and paste function is going a bit haywire. Just bear with me a sec. So, and again, this is a question I haven't got a clue about assured tenants and stuff. So, if someone's been a tenant for over 20 years, that's an assured tenancy, isn't it? Safer, are they allowed to serve a notice to quit on vulnerable person that got assured tenancy? Um, so I generally don't know the difference between assured short hold and assured tenancies and that kind of stuff. But my guess is they can if there's been kind of breaches of the tenancy in terms of not paying rent or something. But again, Will or Karis, I'll leave that. This is in your kind of remit rather than mine and Shannon's.
I'm just looking for that one. Where's it? Where is that question?
It's in
Sorry.
the live stream about halfway down, if that makes
Am
sense.
I missing? Uh, Hang
So,
on.
but it's kind of, I think it's on the back of you were saying before about kind of notice to quits and stuff and kind of what the how the kind of terminology is used and
Is
how
it?
it's kind of an artifact of previous system. But if it's on the screen,
Oh,
so if
right.
you see
Sorry.
it there,
Oh, yeah. So if been a tenant for over 20 years, that's an assured tenancy, isn't it? Safer, are they allowed to serve notice to quit on vulnerable person that got an assured tenancy? Okay. Shall I just try and
yeah, I think I
ask
mean
that?
I mean, as I say, I find it very complicated, but
Yeah.
eventually I'll
Well,
get it if you say it enough
I
times.
think the questions, if I just talk it through, so there's a number of sort of propositions there. Number one, if you've been a tenant for over 20 years, that doesn't mean it's an assured tenancy. Um, an assured tenancy is a tenancy that meets the requirements of the definition of an assured tenancy under the Housing Act 1988, which says it has to be let to an individual. Um, it's got to be for more than 6 months, and it's got to be for a private property. So it will cover most tenancies, but then you've got an assured short hold, which is a subspecies. And initially, as an assured short hold is the one where the landlord can serve the Section 21 notice and get you out without any defence. And at the moment, any assured tenancy where a notice at the beginning of the tenancy saying that it won't be a short hold isn't a short hold, is a short hold. Are you still with me?
No, but I can watch that again. Just say that last
Sorry.
sentence again, Will.
Yeah, in order to be any private tenancy entered into between somebody other than a local authority, usually, and an individual will be an assured short hold tenancy at the moment. So if any of us rented a property out to any of the others of us, it would be likely to be an assured short hold tenancy, except if we served a notice, the landlord served a notice at the beginning saying this isn't an assured short hold, it's just a plain old assured tenancy.
Right.
There's not a lot of incentive for
Yeah, I was going to
landlords.
say, why would they do that? They wouldn't do that, right?
Um, No, they wouldn't. And when they first brought the law in, you had to serve notice that it was an assured short hold tenancy, and that caused lots of headaches for landlords who forgot to do it. So they reversed it and said you've got to have a notice that it isn't one. So that means the default position that is that it's an assured short hold. But let's say, for the sake of this question, an assured short hold is a form of assured tenancy. So let's say it probably is an assured tenancy, but it may be an assured short hold. If it's 20 years old, the test is if it was entered into before January 1989, when the Housing Act 88 came into force, it won't be an assured short hold tenancy or an assured tenancy. It'll be a rent act tenancy. But very few tenancies now are entered into before 89. So then going on, safer question mark. Um, I don't know, safer
I
than
think it's like more secure. Like, yeah, is it kind of less, is it kind of more difficult to evict someone from?
yeah, an assured tenancy means that you can only evict somebody if you've served a correct notice. And any landlords watching will confirm it is a bit of a nightmare because you've got to serve the right notice. And when you go to court, there may be a duty solicitor jumping up saying, look, you didn't put the right date on the notice or something, and then you've got to go back to square one. So it's safer than a plain old notice to quit, which we were talking about earlier, which is what would be served if there was no assured tenancy, if this was just some sort of
If it was a
non,
renters, whatever it was,
let's just say
a rent act tenancy.
if it was a tenancy that had fallen through the safety net and somehow it wasn't assured. Like a home office, like if you're in home office accommodation and they want you out, you've got no rights. Or put another way, if you're in interim accommodation under Section 188 in a hotel, they can tell you you're out tomorrow. And that's what we call really unsafe. They don't even have to serve a notice to quit. But if they'd given you a flat, they could give you a notice to quit because it's non-secure. But then to say, are they allowed to serve a notice to quit on vulnerable person that got an assured tenancy? And the answer is, this is a lawyer's answer. No, they're not, but they can serve a notice of seeking possession, which is what you would serve on an assured tenant. And the fact that they're vulnerable, unfortunately, no I mean, the fact that you're vulnerable wouldn't be a reason they couldn't serve a notice on you, but it might be a defense. It might give rise to what's called a disability discrimination defense if the reason that the landlord was trying to evict you was something to do with your vulnerability. But that would generally only apply to a sort of housing association or other public body. So, but I think the law is expanding so that if, for instance, a private landlord, let's say a person had a stroke or something and had special needs, and for some reason the landlord took against them and then served a notice on them and then went to court. It might be possible to say that this is discrimination. Well, it would be discrimination because they'd be taking action because of the person's disability or the effects of the stroke. So whether or not that would apply to a private tenant, I mean, it'd be good to a private landlord. It would be good to try and run it. But they can serve a notice, yes. What you should do is look into defending it if they issue possession proceedings.
Yep. So I found it helpful. I know Shannon's pulled some faces there. So I don't, Shannon, have you got any questions
Sorry,
about
was
that?
I
Or
saying something wrong?
no, 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 no.
All
You
right.
you
Just got
haven't done anything
confused.
wrong. My brain has just not taken a lot of that in. So, question: how can people find out what sort of tenancy they have? Is it just a case of checking their tenancy agreement? Because in the tenancy agreement, I was under the impression it has to tell you what type of tenancy it is and how they can end it and how you can end it. So for this person that's asking what type of tenancy they have, is there an easy way for them to check? Can they just request it off of their landlord? Can they just check it if they've got a copy? How would you recommend them finding it out?
Um, the answer is it doesn't have to say what sort of tenancy you have.
Really?
Yeah,
Why?
because um, legally your status as a tenant is determined by not other things than what's in writing. For instance, if you said to me, you can rent if you rented your home to me, yeah, you were the owner of your home and you rented it to me as a tenant and said, I'm going to give you the keys now in return for you agreeing to pay me whatever a week. Here you go, it's yours. Then you wanted to take me to court. The first question that the judge or the lawyers involved would say is, what sort of tenancy has Will got? And the answer would depend, but there wouldn't even be in that situation, there isn't even a written agreement. Because you have to ask yourself, what happens if there's no written agreement? And the answer is you have to say, well, does it walk like a duck and talk like a duck? So you have to say an assured tenancy. Remember, I said it's the default sort of tenancy. So if you have a situation like the one I just described, where I've clearly become your tenant and I'm paying you rent. And so that means I am your tenant. So the question is, what sort of tenant am I? And the Housing Act 1988 would bring me within the definition of an assured tenant. And because of what I said about, because you haven't served a notice on me that I'm not an assured short-hold tenant, I think I would then be an assured short-hold tenant. And you could serve a Section 21 notice on me. On the other hand, if you if you were the Home
Hold up.
Office, yeah, go on.
Sorry. No. Because, and I'm sorry to everyone in the chat with like genuine questions, but so I'm hoping this is helpful for people watching. But so in that situation, you just said I could serve you with a Section 21 notice, but how can I do that? Because isn't part of part of the way that that has to be legit is if I've given you all of the paperwork, like the gas safety stuff and the tenancy I thought was
Oh,
included in
very
that.
good question. Yeah. Sorry, I didn't say that. Yeah, you would succeed with that, but the question is then, how would you get me out? Because you could say that I'm not. Yeah, that's a very good question. But the if I throw it back to you though and say, well, what if if you ask yourself this conceptually, can you be a tenant and can somebody else be your landlord if you haven't written into an agreement, a written agreement?
I don't know
And if
because I'm
not,
not a
what's my
lawyer.
status in your home if I've been there for 5 years paying you rent?
Well, I think often, yeah, okay. Let's go back to the questions because I feel like I'm derailing it. Sorry, everyone
No, you
watching.
you got me there with the assured because of course you could serve a notice, a Section 21 notice, but I would have the landlord would have no chance because they hadn't complied with any of that stuff at the beginning. So they would have to I don't know, there's maybe somebody else. I'd have to think about that one because somebody must have had that problem.
I mean, surely, that if in that situation, you're living in someone's house, you're paying them a monthly amount to actually go forward. The landlord would still need to get a gas safety, get a plumber around to check out the gas, issue the paperwork or whatever before they're then going to
Yeah.
try
No,
and go
I
down the
think that's
process.
right. And I think what would happen is that if Shannon wanted to get me out, you'd have to look at all the checklist from the things that you would have had to do at the beginning of the tenancy, and then do them all before you serve the notice and hope that the judge would say, well, okay, you've complied with all the requirements. And because I don't think forgive me if I'm wrong, and some people may be shouting at the screen saying, what an idiot, but I don't think there's any of the requirements for a Section 21 notice which can't be complied with later on
Yeah,
so
because
that you're stuck with the tenant forever if you make
yeah,
one.
yeah. because loads of landlords never did that stuff, but
Yeah.
they'll just make sure that before they serve the Section 21, they have done those things. Which to me, because I mean, there is, again, I'm probably going way off topic. I'm sure it is possible to get compensation if a landlord didn't do certain things that they should have done earlier in the tenancy. But I heard about that like 10 years ago, so I don't know. Yeah, and I never kind of did it myself or anything like that, so I don't know how it would work. But it seemed to be something where actually there was, some kind of incentive on landlords getting it right first time rather than just throwing it all together when they want to actually go down the eviction route. Um, so that actually made more sense that time, Will. So
Oh,
I'm
great,
very
great.
grateful that you kind of went through that. Um,
It's
and
tricky, isn't it? It's
yeah, yeah, it is, and I
I
guess
lost
it's all
it
going
for
to
me.
change in 6 months. It's going to, but me, as I say, we need to do some stuff when we actually know what the law's going to be, actually kind of to kind of explain what we think is going to happen. Um,
Maybe somebody's got a comment saying what rubbish I'm talking
They might say that anyway. It's all right. Yeah. So
Oh, here we are, yeah.
hold on a sec. So I think it's a two-parter. Let me just get both bits together. Um,
Hmm.
so yeah, an individual made homeless application, wasn't given priority need, then made a Section 202 appeal. They're being referred to the private renter sector, but after the individual asked if the council would accommodate him pending the review under Section 7 of 188 subsection 7. What is the difference between private renter sector and interim accommodation under Section 7? What would happen if the council uphold non-priority, and two, if the decision overturned? So, okay, if I understand this question correctly, what the council might be doing here is you've been found non-priority. Um, but in yeah, as in it's not that you've been found non-priority, it's just that they've said that the interim accommodation duty hasn't arisen, so there was no reason to believe you might be in priority need. That's how I'd read that. And so, well, I think I'm reading, no, actually maybe not. No, I'm going to take that back, because they must have made a not in priority need decision at some point to in order to actually allow the Section 202 review to go ahead. um and so what I suspect the council's doing here is they probably realised that their decision was wrong, or is certainly open to be challenged, and therefore they're throwing an offer of bright rented accommodation at the person. Now, I don't think that this could be, although I guess it could, because you can hold the relief duty open. So my question back to this person would be, was there any mention of it being a final accommodation offer, or was it just an offer of bright rented accommodation? I mean, I think either way, you'd be sensible to accept it, because, as we know, like, even if you were to be, yeah, if the decision was overturned and it turned out you owed the main duty, they can still give you exactly the same price rented property in theory. So, probably the sensible thing at this point would be to accept the PRS, the price rented offer, unless it's, you can't live there for some reason, it's completely unsuitable. So I've sent, and this goes back to one of my first case I worked on, where this is exactly what happened. They said that this individual wasn't in priority needs. I challenged it. I was really confident that the council were wrong. But before it got that far, they made an offer of private rented accommodation. She then moved into it, and then the review came back to say, the Section 202 review came back to say that she's no longer homeless. So there was no actual kind of accountability or kind of exploration of whether the decision was right or wrong in the first place, which I found very frustrating. But that's kind of how it would work. So yeah, I think that's I mean, I think, bottom line is, when you're dealing with councils, if they're making an offer of accommodation, really you need to have a fantastically good reason to not accept it, because there's no guarantee. Yeah, and even if you were to hold out, um, there's still no guarantee that you're going to get social housing. So you're taking a big risk. I guess that there is a chance that you might get social housing, but you're taking a big risk in that situation. But I would speculate that might be what's happening here. I don't know if any others want to kind of speculate anything else.
No, I'm a bit scared to guess at this.
Yeah. I mean, I don't know what else that could be. But I think my guess is the council's basically a bit scared that they can see their initial decision was wrong, and they're just basically trying to fix it by making an offer of private rented accommodation, as in like a
Hmm.
short hold tenancy, rather than
Did,
kind of go down the review route.
did you say that if they did, if for some reason after making a negative decision on priority need, the council said, oh, well, we'll offer you private rented or we'll refer you to private rented, and they took it, then my view is that the answers to those questions at the end would be, if the council uphold the non-priority after you've got the private rented, then it's not really a problem because you've got the private rented. And if the decision is overturned, i.e. they accept you're in priority, I think they could then say, well, you're not actually homeless anymore because we found you the private rented place. And unless you can tell us that's not suitable for you, you're not homeless. Is that what you
Yeah,
said, Matt?
that's what I was trying to say. So
Sorry.
it was Housing Reviews Limited. I had that rather frustrating conversation with, because they were like, no, we don't have to kind of actually
Yeah.
check whether the first decision was right or not.
Yeah, yeah.
They're
You're
not
not
homeless
homeless
anymore.
anymore. So
Yeah. So as I say, I think in this situation, um, if I was in that situation, I would accept the private rented, as I say, unless it is so unsuitable that you can't move in, and you still would then accept it and then challenge it through the suitability of accommodation or whatever. It's a very, very difficult situation. Unfortunately, it's one of the ways in which the power imbalance between councils and homeless people you really sort of see play out, because they can just they can kind of, they've got these kind of little tricks they can play to to kind of shoehorn you into private rented accommodation anyway. And there's not a lot you can do about it. So that decision might have been incredibly perverse and might be outrageous even, but there's no comeback if they make that offer, unfortunately. Um, yeah. So hopefully that made sense at least. Um, so I'm not quite sure if there's a question there or if that's just a statement there. So I think this is the next question here. How does one request suitable accommodation, i.e., property with lift and handrails and soft flooring for bathroom in case of seizure? Okay, I'm guessing we're talking about here someone with something like epilepsy or something. That is definitely both a care and support need and also a disability. And therefore, again, I mean, the law is one thing, what councils do is another thing. But what the law would say is that if the council is aware, and they should be aware, because they should be inquisitive and they should find this stuff out. If they're aware that they have someone with a condition like epilepsy, not saying it is, but it's something like that, then there needs to be that contemporaneous record in their notes which says we have carefully considered this person's disability and their care and support needs. We've involved social services if necessary and all the rest of it. And we are satisfied that the property we are offering is going to be suitable for that person. Now they might say, we're getting an OT in to put some handrails in. I guess technically they probably should do that before the person moves in, but in the real world it's probably a slightly different thing. But essentially they would need to be able to account for how they've taken that person's health needs into account when deciding it was suitable. And those things are very much, it may, you'll often have kind of situations arise where those kind of conditions like epilepsy, actually a lot of accommodation will not only be not suitable, but it also won't be possible to make adaptations to make it suitable. It would need to be a particular type of property for certain conditions in order for it to be suitable. So that's kind of, I think that's the legal answer. I think the kind of the pragmatic, how do you actually get that? One thing to do would be, if you haven't already, is to approach social services, adult services that is, and get a Section 9 assessment. So you can literally just march into any council or ring them up and just say, I want a Section 9 assessment, please. They'd have to kind of look at this, and these kind of things, this is their bread and butter. So I would hope that you wouldn't get much resistance from social services. They'd probably get an OT involved and so on, but this is something they do all the time. And so I think that's, if you can get that kind of medical evidence, that social work evidence, the OT evidence or whatever, which says this is the type of accommodation this person needs, then the council would be really, really stupid to disregard it. It'd be very easy to challenge them if they disregarded it. We go back to that kind of point I made about requesting a review of suitability. If a situation, if you had a medical condition where you needed soft flooring and handrails and stuff, and the council hadn't provided it, then I don't really see how they're not going to lose that argument. But unfortunately, you might have to have it still. So just to say, guys, this is a weird. I know it might seem like a weird rule, but if you're asking questions in the first person, I'm going to remove them just because I don't want personal data on the chat. So please rephrase the question as a what if question, if that makes sense. But in terms of question 8, guys, anyone want to add anything at all to that in terms of a better way of doing it, better way of requesting suitable accommodation. I think the other thing I maybe have said but might want to say again is make sure you're asking for it. So when you're triggering the homeless application itself, in your initial email, you want to include details about your medical conditions and also what adaptations need to be made as a result of it. Although the council should find this stuff out themselves, they probably won't. So you need to just basically spell it out for them that that this is the case. So yeah, hopefully that makes sense. Cool. So probably going to put call time on further questions. So just to say again, guys, if you haven't had your question answered or you don't get time to answer your question tonight, stick it in the chat, stick it in a comment on the channel, and you'll guarantee getting an answer then. So okay. So question 9. Oh. How much time do the council have to make a decision on priority after issuing interim accommodation under Section 108 to the individual? Is it 56 days after issuing interim accommodation they have to? So pretty much, yeah, but although there's a slight kind of nuance to it.
There's a second part to that, sorry, Mike.
Oh, sorry, yeah, nice one, thanks, well spotted.
You've worked it out, but yeah, just for other people watching.
Yeah, cool. No, thanks, Shannon. So yeah, basically the day they give you interim accommodation is not necessarily the day that the relief duty starts, though it can be. Probably isn't. The relief duty probably starts a few days later. And it's 56 days from when the relief duty starts. That's the kind of the official time limit. So in most cases, council should reach a final decision about priority needs on day 57 after the relief duty starts. And the guidance then goes on to say that in cases of exceptional complexity, then you can have another 3 weeks. But there are they're not stories. There are LGSCO decisions where basically the people were left in relief duty for months, even over a year. So that's not unusual. But in one sense, if you're confident you're in priority need and the council's delaying the decision, that is a very good situation to complain about it, because by getting them to do the right thing and by making the decision when they should do, you're increasing the chance of getting decent housing. That's a long story short, but that's what you should do, really. So yeah, if you go on, there's a video on this channel called "How Long Should the Decision Take?" and I go into more detail about that. So yeah, yeah, so I think that question about assured, I think if you go back and listen to what Will said, I think he basically answered that additional question there. Yes, don't worry if you didn't kind of follow what Will was saying about all that stuff. Watch it again. I think I got it the second time basically, but unfortunately it is very complicated. So yeah,
without wishing to drag you back into that sort of particular stage, were you saying that the point with the hand wave has been addressed? Because I think it's that one, isn't it? But just before I don't get what Will's saying.
Yeah. That's so. I think you did. I think you answered it, Will. I think so.
Well, I think the guys pointed out. Sorry, the person. Is it Tiff actually that's asked that one?
Yeah.
Where it says it, if you notice the key thing in that, it says it's a council property, yeah. So it can't be an assured tenancy. It's what's called a secured tenancy or a council tenancy, because an assured tenancy can only be entered into with an individual, a private landlord. So a council property isn't assured, and they would have to serve a notice. If you wanted to get a council tenant out, you have to serve notice, and a different sort of notice of seeking possession, I think, under the Housing Act 1985. So the answer to the question going back is you haven't got an assured tenancy, you've got a council tenancy, which is even safer which is probably the safest of the lot. So congratulations, and thank you for pointing that bit out.
I guess it's probably just worth saying though that you can still get evicted from a council tenancy if you haven't complied with the terms of the tenancy. Basically, it's still possible. So so I don't think that changes what you said about kind of actually getting evicted. So Yeah, I mean, as I say, yeah, it's complicated, but I'm convinced that we'll, if you listen back to what Will said, I think yeah, I got the I think I got it in the end. So yeah, I'm just seeing if there's a yeah. So just in turn, yeah. So I'm not going to put this onto the Word document, but there's basically a question there about whether the Section 21 is not valid. If the Section 21 is not valid, then you're probably not going to be homeless. You might be homeless for another reason, like you can't afford it, or it's generally unsuitable or something. But yeah, if you when you go to a council in this situation, the council's first question should really be, let's see your paperwork, let's see if the Section 21 is actually valid, and if it's not valid, then yeah, you're not going to be homeless. And you're not yet threatened with homelessness either yet because there's no valid Section 21 being served. So the council's probably correct there. And the answer is the landlord needs to pull the finger out and actually serve a valid notice if they want to evict that person. And then once you get the valid notice, you can go back to the council and then you can kind of make the homeless application. So yeah, yeah. So just that is the reason why my question skip. Yeah. So the if you're new to the channel, I know this is a weird thing, but basically, when you ask a question, I don't want people to have to put personal data on the internet to get answers. Therefore, if you ask a question, I am in temporary accommodation, what should I do, or something like that, I won't answer it. I'll delete it. If you ask a question, what if someone was in temporary accommodation in this situation, what should they do? That's a different question. You're not then having to put personal data on it because yeah, for various reasons. I'm big on data protection anyway, and it also helps people. Um, it helps people see things. It probably helps people separate the stress from the situation from the actual legal issue, and we can only help with the legal issue. Basically, there's not much we can do in terms of kind of helping people with the stress of it. But so yeah, if so that for that person, if that person wants to rephrase the question as a what if question, I will answer it tonight. But yeah, so hopefully that makes sense. Whilst we're waiting for that, I will go back to the questions from the week that weren't anonymized. So you'll notice that I'm answering questions that were not anonymized when they came in through the week because you guys can't see who made it. So there's a separation between the person's name and the question itself. So unless you want to dig through 250 videos on the channel and find that question, you're not going to find out who it was that answered it or asked it. So yeah, oh, wait a minute, I was done that right. Uh, Copy paste not working again. Hold on. So another question about suitability here, which probably fits in quite nicely with what we've been talking about tonight. So what are the council's duties towards suitability? Until recently, formal complaint made, questions about suitability have been ignored or denied. How can someone challenge suitability decision themselves? Only 21 days and difficulty finding legal aid solicitors, plus I don't cope well with admin tasks. OT report, not specific OT housing assessment, instead generic report. What might help in a report with housing suitability or medical grounds? And then thirdly, last response from council doctor basically says needs are not medically essential. So okay, basically the probably the key to this one here is making sure your medical evidence actually supports what you're saying, because it's no good having a letter from a doctor saying, yeah, this, my patient would benefit from having a 2-bed home rather than a 1-bed home, with a garden or something. That's meaningless. You have to get the professional to say why, and effectively you have to kind of specifically tie the medical issue or the care and support needs to the characteristic of the home that you basically need. So I might do some videos about this at some point because there's been a few LGSO cases involving overnight carers and stuff and how that should be assessed. But you basically need it needs to be really kind of clear. This person needs this type of accommodation. And so a generic letter that says this person would benefit from some nice homes or something, that's not going to do anything useful. In terms of C, so the council's doctor may well be now medical, which you don't, that they're going to say that a lot. They don't never actually meet anyone. It seems they don't actually assess anyone's actual medical needs, and they seem to diagnose people without ever actually having met them. So don't worry too much if the council's independent medical advisor is basically saying no, but do worry if your own medical people, your own OT or whatever, is not actually being very clear. And if your OT is not being very clear and they refuse to be clear, then I'm afraid you're probably not going to win that argument. So yeah, you'd assume that the OT is basically not satisfied that that particular characteristic is essential after all. So yeah, but that's kind of that's what you want to do. You want to focus on getting decent supporting medical evidence, which is clear and specifically talks about the type of accommodation you need because of the medical issue. And then once you've got that kind of evidence will basically blow this kind of evidence out of the water. It will basically trump whatever the independent medical advisor is saying. So yeah, anyone want to add to that at all? If not, we'll get on to the last one from the week, and I'll just double check that. Yeah, so as I say, if that person wants to ask that question again, they're very welcome to. But yeah, question. What's it? Let's collapse that. So question 11, if someone is genuinely unwell but does not like to go to the doctors and uses only private sector doctors, I'm assuming here, can housing officer reject private medical letters or claim a person does not seek medical help often enough to be vulnerable? Can they demand impossible things from people? So the answer to that is no, but I don't think that's actually a question that we're really asking here. If someone is not registered with GP or has not been for a long time, can they demand such a person's medical summary? If the private provider does not supply such documents, what to do? If a person uses healthcare abroad and it's expensive to translate and get new documents, can they demand this? Can they disrespect the clear possibility someone may be vulnerable and claim they're not until they prove it? If someone suffers from asthma and allergy since childhood but lost all documents, what should they do? What can do if the council does not treat a person as homeless, even if contact? Okay, so I think actually I put this question at the beginning, so ignore that last bit. But basically, so this is an interesting question, and I think that there's obviously a legal answer, there's obviously a pragmatic answer here. The council to provide interim accommodation, the council has to have reason to believe that you might have a vulnerability of some sort, which could involve medical issues, it could involve kind of asthma and allergies potentially, depending on how severe they are. That's kind of the first threshold. But then the council's next job when it comes to priority need is being satisfied the person does have a priority need. And that is not the same thing as proving beyond all reasonable doubt, but they do need to be satisfied. And I do believe there'll be situations where the council doesn't need medical evidence. They don't need it to be satisfied. There might be other reasons why they believe it. I've certainly worked with housing officers who can see someone's presentation and say, yeah, do you know what? Fair enough, mate. You're clearly, kind of shaken and clearly got some mental health issues, and they didn't request the medical evidence. But I think also housing officers are well within their rights to request it. There are some interesting LGSCO cases where the applicant refused to give the GP's name. I know that's not what we're talking about here, but that's the kind of case came up. And in effect, the LGSCO kind of supported the council's position, which they were saying, we need to make these inquiries. If the person prevents us from doing that, then what are we supposed to do? How are we supposed to be satisfied they are in priority needs? Now, there is an additional thing to this where you might, and I'm not saying it's necessarily relevant here, but let's say you've got someone who has got paranoia, and actually they might not even be saying they've got paranoia because of the nature of paranoia, and they might not be going to a doctor because they are paranoid about the doctor. A good housing officer will probably see the signs of it and they will act accordingly. So they're not going to insist that the person goes to a doctor if clearly that person's exhibiting psychotic symptoms or whatever. But I don't think that's what we're talking about here either. So I think ultimately, in terms of kind of can the council insist that it's translated, probably say that is probably the council's job to do. If there's evidence that's kind of relevant to medical stuff, which is in a different language, then I think the council would need to get it translated. Even if you just use kind of Google Translate or something, you probably get the gist of it. So yeah, I think that's the kind of and yes, I'm just trying to get all the truncated questions. So I think where you've got a situation where you've lost all the evidence, then you need to go get the evidence back. If you've got a medical letter that you've lost, the doctor will have a record of that. If we're talking about EU countries, then the GDPR applies. Same rules around data protection apply. You can basically make a subject access request and get those medical letters or whatever from a surgery in a different country if it's in the EU. I'm assuming there'll be similar things in place in other kind of America or whatever. So yeah, I think that's answered. I think bottom line is it's reasonable to want some evidence. But yeah, so I'm just trying to make sure I cover it all. Again, private doctors or whatever, there's no reason to disregard the fact that just because they're private. I mean, in one sense, in Will and Carris's work, they'll get private doctors to do assessments. They are absolutely legitimate. That's kind of part of the normal process. So yeah, I think I've kind of covered all the bases there. But yeah, it would depend on what the private medical letters say. But just because they're private, that doesn't mean the council can reject it. That they're still doctors. If they're registered doctors, then they're still kind of bound by kind of various oaths they made and stuff, and duty of candor and stuff. So yeah, I think that's covered all the different arms of that question. So yeah, anyone anything to that at all?
Just a tiny bit, if I may. I think you covered everything, so I won't go into it in detail. But it's interesting. This question does. I mean, I'm not wishing to sound unsympathetic to the general stuff because I think the council do have a duty to make inquiries and can't refuse to do that. So I think the council position that's often being referred to here is unreasonable. But we always talk about if they've got reason to believe and that's being a low threshold. I think this question here sort of shows us a situation where it may be even lower than the low threshold. So it says, can they disrespect the clear possibility that SB may be vulnerable? And I'm afraid the answer to that is yes, unless they've got reason to believe it. So the fact that it's a mere possibility wouldn't, in my opinion, mean that the council had to accept you were vulnerable. They'd have to have some reason to think that the possibility had come true, if you see what I mean. And
So
that's not that difficult to do, but
Is
uh,
sorry.
you go on, Shannon.
I was just gonna say, even if it's like expensive to get the medical records from the private company, is there a way almost where this is private, right? So you've paid for it in some way. Most people have online banking. If you were to screenshot payments to a private healthcare company, would that not trigger the low threshold of reason to believe that they've got some medical stuff going on, which might account to a vulnerability if they're showing that they're
yeah.
paying private healthcare? I know that's a weird because it's not
No, I would say that
medical evidence, but like,
yeah, I was just saying that hypothetically, in abstract, if I said to the council, it's possible that I'm in priority need, they would say, well, give us a reason to believe that it's more than possible, if you see what I mean, that you are. And if I couldn't do that, I mean, I could just say
Uh,
to them, I'm in priority need because I suffer from these conditions. And if I've told them that I suffer from the conditions, then I think that would give them reason to believe it. Unless I told them I suffered from a condition which I clearly didn't suffer from, like
yeah. So yeah, I think because it wasn't that. Yeah, if I said, "Oh, I've only got one leg," and the person looked at me and said, "See, I've got two legs," then clearly there's going to be some problems there. But I would potentially take issue with that threshold, Will, in terms of the way you said it. Now, I don't know. Again, I might have misheard it, but yeah, so because whenever I hear people talk about reason to believe, for me, the most important part of that situation is, or that kind of that wording is the reason to believe that you might be rather than being satisfied you are. And in one sense, the
yeah,
reason to believe bit is not actually the important bit, it's the might versus the being
yeah,
satisfied you are. And I think people often kind of conflate and say, oh, I don't have reason to believe that you are in priority need. But that's not the test at that point. It's reason to believe you might be in priority need. And I'd agree with you when you say if I went to a counsellor and said, I've got some really serious allergies and really serious asthma, then yeah, then you'd be given the reason to believe that you might be in priority needs. But I think the kind of I often see people kind of conflate the two thresholds
yeah.
into one, and it
It's a
creates a bit
dangerous
of
thing to do, isn't it? Because you can end up crossing the line and being sort
yeah,
of unreasonable. But if I simply said to the council, I'd like you to house me because I may be in priority need,
yeah,
and
yeah,
they said,
yeah,
well, what do you mean? And I said, I don't know, but it's possible.
yeah, yeah,
Um, then they could say, well, sorry, but that even the low threshold isn't crossed here.
yeah, yeah, yeah,
I'd be pretty dumb if I didn't say to them, I've got but then again I could be. They could say this guy must be in priority need because he sounds like he's got mental health problems because he's telling us he won't tell us why he's vulnerable.
which,
Uh,
which which I think genuinely, I think I'd be really interested to see council officers get that training on what to do there because
mm,
you do have those individuals who like as a non-medic you can clearly see they're not very well and yeah, they might be refusing to comply or cooperate, or whatever. But I still think that the council would have duties in those situations to do something. So the person just rephrased the question. So although I've kind of called time on new questions, this person did ask the question before the cut-off point. And so, and just double yeah, and just get it all together. So yeah, and just to reiterate, this is why it's better to ask the question on any video in the channel rather than on the live stream, because there's no character limit. But yeah, if someone has already been accepted for main housing duty, but their housing officer offers them PRS accommodation during the relief stage, should they accept it now? So if the main duty's been accepted, the relief duty's ended. So that shouldn't happen basically. So potentially the housing officers getting confused. They can make a private rented sector offer at the main housing duty stage, but it's no longer it's not the relief stage anymore. There are a couple of really complicated obscure bits that might kick in there, but basically just to kind of clarify that you are owed the main housing duty, which can only be discharged in one of two ways. One of which is an offer of Part 6 social housing, either council housing or social housing, or a 12-month assured short hold tenancy in the private rented sector. And so one of the questions you might want to ask the housing officer is it a 12-month assured short hold tenancy? And if the answer is no, then you just say, well, this isn't a legal discharge of the main housing duty. So but yeah, going back to what I said earlier, in the real world, if they're offering you accommodation which you can which is halfway reasonable, then I would say probably best to accept it. In a situation like we're talking about here, you might just want to first clarify with them that it is actually a private rented offer in relation to the main housing duty rather than the relief duty. But once you've done that, then I'd say, yeah, I mean, basically, you kind of have to. If you refuse the private rented sector offer at the main housing duty stage, and there isn't a good reason for refusing it, then which having a disability and kind of needing to stay local might be an issue, might be relevant. But without any kind of reason, then you really don't want to refuse it. Again, I think if you're having that kind of argument with the council that your disability requires you to stay in the local borough, you need to provide a clear, specific link between the disability and the need to remain. Because if your argument is, I need to go to my GP, the council will probably say, well, there's GPs everywhere, so you can go to a different GP. Whereas if you're saying I have a disability, I need to be close to my family support in order for them to help me out or whatever, that's a much better argument to be making. Or if, and it doesn't happen very often, but if you have a very specific medical issue which requires you to be kind of close to a very, very specific kind of specialist service, then that's probably a better argument to make. But it just kind of depends on the facts of the case, really. So, yeah. So anyone who's asked questions after that bit, all I can suggest is you go straight onto the YouTube channel now and put your questions into the comment section on any video, and we'll basically ask it next week for sure. But other than that, hopefully it's been useful. I certainly found it interesting. It'd be good to talk more about, as I say, about these kind of changes to legislation and just kind of how these different tenancy types are actually going to continue to exist. But we'll do that I'm sure at some point. But yeah, cool. Thanks, guys. As always, thanks for your time. Thanks for the good questions as well. And we will see you next Thursday on this channel. Hopefully Monday on Will's channel. I'm getting waiting for a nod. Yep.
Yep.
Cool. So yeah, take it easy, guys, and hopefully this has been useful. And hopefully things get better at some point for you.